State College Board of Trustees and United Faculty of Florida. This is September 29th, 2020. Will the parties please state their appearances for the record for the union?
Yes, this is Graham Picklesheimer, Service Unit Director for United Faculty of Florida, Chief Negotiator for the union.
For the employer.
Good afternoon, it's Brian Koji with Allen Norton and Blue. I'm the negotiator for the college.
And prior to this hearing, I've received exhibits, and we'll go through these. Well, I've gotten, I think the parties are going to identify these as they go, correct?
That's correct.
Yes.
Okay, so I've got exhibits 1 through 10 from the college. Is that the right number? Did I miss any?
No, that's correct.
Okay, and I have for the union 1 through 5, and exhibit 3 is really multi-part, correct?
That's correct. Yes, sir.
Okay. And before we go anywhere, I know this has been a difficult dispute, shall I put it that way? And I will give the parties an opportunity if they want to. We can see if we can go. Do we have breakout rooms set up?
I have not set that up.
Okay. Well, let me put it this way for council. Do you see it as fruitful to try and give an opportunity for the parties to discuss further settlement, or are we pretty well fixed?
I think at this point we're pretty well fixed. We've kind of gone round and round on just the concept for well over a year. I think Mr. Koji would probably agree that it's unlikely that either party will change radically its position.
Then I don't think we'll, because it's a little cumbersome to set up all the breakout rooms now and try and do this if it doesn't work. It's not likely to work. Okay, with that, then I think is there anything else we need to do before we proceed?
I guess just for clarity's sake, I know I mentioned when we received the college's exhibits that the union didn't have any objections, not going to, require foundations be laid or anything like that. Ryan, how do you feel?
Yeah, no, we don't object to any of the union exhibits that were circulated earlier. Mr. Michael Stetter, Graham and I talked before the hearing, communicated as to, since we only have the one issue, and I think it's less of a factual issue, more of a philosophical issue, that we felt like probably, while I think I would present a witness just to go through some of the board policies, be done through presentation of the documentation and argument from the representatives. Assuming Graham still feels that way, that's basically how I intended to proceed this morning. A little bit different than we typically do, but if everybody's on board with that, that's what I would suggest.
Yeah, that works for us. We're going to have a couple of faculty members sort of speak to the importance of the issue for them and for the faculty, but otherwise, yeah, I think the documents mostly speak for themselves. Just kind of refer to them while making, I guess, oral arguments.
So are you going to introduce them basically in your oral argument, just go through the exhibits, or are you going to have witnesses for the exhibits? I mean, I agree, we've agreed not to necessarily lay a foundation, but we certainly have to explain at least to me, the significance of the exhibits in this proceeding. So it's got to come in one way or the other. So
yeah, sorry, go ahead.
I said, how do you plan to proceed?
Yeah, I think as we're going through the presentation, the points at which the exhibits become relevant will be made clear. So if that's to everyone else's satisfaction, I think that's how we prefer to proceed.
Okay.
Yeah, that's fine with the college. And from my perspective, I intended to do the same thing during the argument, kind of refer to some of the exhibits, but I would likely call, or I would call one witness, if you will, relatively short, the Human Resources Director, just to walk through some of the board policies that I think are relevant because he's much more familiar with the ins and outs than I am. But I think it's just really to walk through those just so that you understand.
Okay. Okay. Now, unless the parties see it otherwise, the union's the moving party in this case, and I would expect them to do an opening at this point and proceed with their case. Does the employer want to make an opening in response to the union's opening, or you just want to do your case and do your opening with your case, with the college's case?
Yeah, I would just soon do it with the college's case, but I'm open to either.
That's fine. It's up to you. Okay. With that, Mr. Pickelsheimer, you want to proceed with your case, your opening in your case?
Sure. Let me just go ahead and share my screen real quick here. Okay, so I do have captioning turned on in case any observers are desire that or need that. But I think the opening here is pretty simple and straightforward. Just kind of go through the factual background.
I try not to interrupt, but I'll interrupt at this point. Is this a first contract?
Yes.
Okay. How many people are in the unit?
About 130, I believe, on that order.
Okay. Go ahead.
Thank you. So just some background, since this is a first contract. In 1967, the Florida legislature established the college. It was the last sort of link to be put together of the Florida college system. For 50 years, there was no union. And then in April of 2018, the union won an election. PERC certification number 1930 was issued. Almost a year later, the parties began negotiations in February of 2019, held 26 sessions between then and August of 2020 when the final session was had. So a rate of about once every 3 weeks, fairly quick for a first contract. We were able to reach agreement not only on numerous 14, by my count, articles in the collective bargaining agreement, but also 5 memoranda of understanding covering various topics. The one issue that we were not able to resolve is regarding discipline, and the union's proposal you'll find in Union Exhibit 1, and management's proposal at this time is to not have discipline language in the collective bargaining agreement. Just to briefly kind of outline what the union proposal is, this is Union Exhibit 1. Don't feel I need to read it, but just kind of summarize some of the main points.
Yeah, okay. And just one new cited exhibit here, I'm going to have to shuffle a little bit just so you know, but okay, I've got Union Exhibit 1. Okay,
great. So there's 3 sections. First section titled Just Cause and Disciplinary Actions. Pretty straightforward, provides that discipline is for just cause and gives some elaboration on that concept. It also defines different steps of progressive discipline and contains fairly standard language that the ladder of progressive discipline, as it were, can be jumped in the event of a serious offense. There's a second section on procedures, which really just describes in more detail each of those steps of progressive discipline as provided in Section 1. And specifically reserves, sometimes this is a point of contention, specifically reserves for management the right to put employees on what's sometimes called administrative leave, relieve them from duty with pay while an investigation is pending. Third section, other provisions, covers sort of a variety of topics that are within, the spectrum of what is typical in discipline language. Anonymous complaints can't be used as evidence in a disciplinary proceeding. They can, of course, lead to an investigation that results in other types of evidence, but they are not themselves evidence. The employee has a right to know generally what they're being investigated for, as well as where complaints have been made, the source of those complaints following the end of the investigation. the right to union representation at disciplinary meetings, right to respond to disciplinary action as provided in state law, right to have disciplinary matters discussed in a private setting, and specifically provides that an annual contract, which virtually all employees in this bargaining unit hold for the first 5 years of their employment, can be non-renewed without cause, and the decision to non-renew is not subject to the grievance procedure. That's a proposal in a nutshell. We feel it's pretty well within the spectrum of what's standard in collective bargaining agreements. Didn't really have too much exchange on a lot of the details here because, as we said earlier, we were sort of hung up on the concept, but this is the full proposal as it stands at this time. The management proposal, I'm sure you'll hear about this from Mr. Koji as well. The current proposal they have today is to not have discipline language in the collective bargaining agreement. As you see from one of his exhibits, of course, there was discipline language exchange at the table. That was not always the position of the college. The proposal that, the various proposals from the college all sought a waiver of the union's right to file a grievance challenging termination particularly, but other forms of discipline as well. And the argument was that there's an administrative hearing process that currently exists, that's kind of always existed for handling employee discipline, and the college is happy with that system. When the union did not prove willing to agree to waive the right to file grievance, that proposal was withdrawn.
So the question is in the administrative, because I haven't been able to go through the exhibits, the administrative hearing process culminates in a decision by a hearing officer or hearing examiner or whatever.
Yes, and in fact, the next slide goes into a little more detail about this process. Okay,
and is it a recommendation to the board or is it binding?
Correct. It's a recommended order to the board of trustees. So yes, the statute, chapter 120, is the chapter that provides this process. If a faculty member holds continuing contract, they can challenge a suspension or a termination through the Department of Administrative Hearings, what we sometimes refer to as DOA. And DOA appoints an administrative law judge. That judge conducts a hearing, receives evidence, all that good stuff. And then they issue a recommended order with findings of fact, conclusions of law, and a recommended course of action for the agency to take. In this case, it would be the Board of Trustees. The Board of Trustees can then adopt that, or they can dispute conclusions of law and sort of substitute their interpretations of their rules for those of the administrative law judge, and they can choose another course of action according to the conclusions it draws. Checked with Mr. Koji about this. No one's aware of any situation where this has been used in the last 15 years or so, so it's rarely invoked to begin with. If this process were invoked, UFF would provide legal representation to members throughout this process. So obviously the union didn't feel that this was adequate, hence today's proceedings, for a couple of reasons. One, there's a cost issue. The regulations that govern DOA process generally requires that representation be provided by an attorney. There are some exceptions to this. We feel this would pose an undue financial burden on the union, because part of the model that United Faculty of Florida uses is not to rely on retained counsel for processing every grievance. We have a number of trained staff around the state who are salaried, who try these cases generally. And so the DOA model, which would essentially compel the union to spend its money retaining counsel, we don't think is necessarily a fair thing from a financial standpoint to require the union to do. issues of sort of certainty in the outcome. As we just discussed, the agency, in this case, Board of Trustees, has pretty significant latitude to dispute conclusions of law, and that can potentially lead to further litigation, let alone the fact that, you know, the outcome you get from the DOA hearing is not necessarily the actual outcome. And finally, nobody likes to hear it, but it's just a fact. The Board of Trustees, being the employer party to this labor management relationship, is just not necessarily going to always be a disinterested party in all cases. So we see value in having an outside arbitrator for that reason. But be that as it may, that's not the proposal before you today. The proposal before you is whether, or the issue before you is whether there should be discipline language or whether there should be none at all. This is all just background and explanation of kind of how we got to the point we're at today. So before we get into the nitty-gritty of the arguments, I'd like to ask a couple of faculty members to sort of speak to their concerns and their perspectives on why this issue is important. So Mr. Michael said,
are they providing evidence in this case? Is that what you're doing with them?
They will not be providing evidence. They will just be providing perspective.
I think if they're going to have something that I'm going to consider, I'll ask everybody to just raise their right hand at home, obviously, and swear to tell the whole truth and nothing but the truth. Just if you say yes, okay, then we're done. Fine. I just want people, I will swear people who are witnesses or providing evidence to as witnesses. Okay, go ahead.
Thank you. So the first witness I'd like to call is Caitlin Guiley, the president of the union.
Do I need to do the swear?
No, I think you did it. Yeah, didn't you?
Yeah, I'll do it again. Okay. Thanks, Graham.
I don't swear at people more than once.
Okay. All right, thank you. All right, imagine you are a new dean at PHSC. A faculty member in your division got into a verbal conflict with a student. What should you do? The institution you worked at previously was unionized, so you turn to the collective bargaining agreement to see what PHSC's policy is. But there isn't a discipline article. You are uncertain as to how to proceed if there is no clear policy. So you talk to the dean of one of the other divisions. She says just talk to the faculty member and let him know that he should be more careful in the future. You talk to the dean of the other division and she says she would put a note in his personnel file and notify the president. You turn to the board rule and it is unclear. Which is the best choice? The written policy offers little guidance and there is no consensus among the other deans. Now imagine you're the faculty member. You know that it was a mistake to argue with the student. The dean contacts you and says she would like to speak with you about the issue. You are a union member, so you go to the collective bargaining agreement and look for a discipline article. But there isn't one. What do? You have no idea what's going to happen. Will you get something written in your personnel file? Will you get fired? If you are terminated, what would you do? Could you file a grievance? You speak to some colleagues. One says that a faculty member in his department got a written reprimand for something similar. That faculty member filed a grievance with the college but never got a response. Another colleague says it's not a big deal. You have no idea what's going to happen, and this is adding to the anxiety of meeting with your dean. You have not been at PHSC that long, but you heard that one of the reasons faculty unionized was that the faculty found that the administration changed policies without notice and did not always follow policies. You wonder, why is there no discipline article in the contract? Now, imagine you're the student. The professor yelled at you in a very unprofessional manner. You think there should be consequences. You talk to the dean about the issue and she does not seem to have a plan. In frustration, you contact the college president and say that your professor should get fired. You ask what the procedure is for terminating a faculty member and the college president has no answer. PHSC starts to seem disorganized to you and you decide to enroll in St. Pete College next semester. These are potential problems that could arise from the lack of a discipline article in a collective bargaining agreement. A discipline article would clarify the steps to be taken in the event of faculty misconduct for all college stakeholders. Administrators, faculty, students, and the public could all turn to the collective bargaining agreement for a transparent procedure for how to handle faculty discipline. Although these situations do not arise frequently, when they do, it benefits all those involved to have clear and consistent expectations of how to proceed. The alternative of having no discipline article in our contract would mean that discipline procedures remain mysterious and inconsistent. Relying on board rules is insufficient. Board rules are not collectively bargained and they are not contractual. There are many reasons the faculty at PHSC unionized, but one of them is a lack of trust in the administration. A clear discipline article in our collective bargaining agreement would work to build trust and improve relations between faculty and the administration. There really is no compelling argument to keep such an important issue out of a collective bargaining agreement. Thank you.
And I'll allow for cross now as we're taking this. Do you want, Koji, do you want cross on this?
Your Honor, I don't think we need to do a cross this afternoon.
Okay. At all or on, just on?
Well, I'll just say on
If you want to have a cross, let me know.
Okay, I don't know what the other's going to say, so.
Yeah, okay. Yeah, just if you want cross, be sure to let me know.
I will do something.
I'll try to ask, but we'll do it. Okay. Mr. Pickles-Heimer, you want to go ahead?
Thank you. Yes. The next faculty member I'd like to call is Gary Esch, who is the chair of the union's bargaining committee.
Good afternoon. Thank you for allowing me a few minutes to say a few things. The first thing is a couple points of mine, and then I want to share with you some other faculty members' concerns about not having a discipline proposal. Without a clearly defined and transparent discipline policy, neither the administration nor the faculty will have a delineated progressive discipline policy to follow. The administration will talk about how there is already a clearly defined process for discipline. They say that there is a statutory process that already exists. The problem here is that no one understands the process. It is a legal process that relies on precedent and case law, etc. There is no good thing that comes from this. It's not transparent. And the administration can still do what they want in the end anyway. As the chair of the PHSC bargaining team, I want to share with you some fears of our faculty members that they've communicated to me in the last couple of weeks. First, without a clearly defined policy, the administration would have free rein to do whatever they want when it comes to discipline. Second, without a clearly defined policy, administration could change how they proceed in each case of discipline. On a case-by-case basis, faculty could be dealt with differently. The potential for discriminatory practice in discipline is possible. Unfortunately, the administration has a history of changing policies and procedures without notification. This is the biggest reason the faculty voted to unionize in the first place a couple years ago. Without clearly defined, transparent policy, faculty and the public would be suspicious of any disciplinary decision made by the administration. Faculty members are already suspicious. There's a lack of trust in the motives of administration, and especially now that they don't want a discipline article. This is not good. The administration is creating more of an environment of distrust. Without a clearly defined and transparent policy, the administration might be opening themselves up to grievances and even possible litigation. This could be extremely costly to the college. Without a clearly defined and transparent policy, trust in our institution could be tarnished. And then lastly, without a clearly defined and transparent policy, faculty members will not know how the discipline process proceeds if they're accused of wrongdoing. Without a disciplinary article, and if I'm accused of wrongdoing, the first thing I ask is, what is the process? The administration at this point would not know the process either. I would already be stressed out if I was accused of wrongdoing, but I don't need the added anxiety that I would be in the dark about what's going to happen next. It's not right to add this additional stress onto a faculty member who has been charged with a violation of the discipline policy. We need to know what the policy is, and that's why we're asking for it to be included in the CBA. Thank you for your time. I appreciate it.
Okay, Mr. Koji, do you want to ask anything?
No, sir, I don't think it's necessary.
Okay, go ahead. Mr. Picklesummer, you want to go ahead?
Thank you. So now we'll get a little more into the meat of the rationale for the union's proposal here. And really there are three. We'll go through them in turn, all based in the statutory factors that I'm sure you're familiar with. One being the prevailing practice among comparable employers specifically, but not necessarily limited to those employers who are comparable in the region and those employers which are comparable, similar nature and size throughout the state. Second, the interest and welfare of the public. Finally, the availability of funds. So first, we're going to look in some detail at the prevailing practice among comparable employers, and this is what that rather large Union Exhibit 3 is about. We'll sort of outline on each slide exactly which of the agreements we're looking at. So first, we're looking at the public employers in the region, defining region here to be the counties within and adjacent to the district. The district, of course, being Pasco and Hernando counties, shown in dark blue here, and the counties around them in lighter blue, clockwise from the top: Citrus County, Sumter County, Polk County, Hillsborough County, and Pinellas County. So within this region, there are two types of public employers that we would submit are sufficiently like Pasco Hernando State College to be comparable. One being institutions within the Florida college system that have collective bargaining agreements. There's only one at this time, and that is Hillsborough Community College. And the portion of their collective bargaining agreement dealing with discipline is the first of that large composite exhibit, which we've marked 3.1. And second, K-12 public school districts with collective bargaining agreements in this region, which is really each of these counties, Union Exhibits 3.2 through 3.8. And we think these are similar enough to be valuable for purposes of comparison because they draw from similar groups of employees, they perform similar functions. In fact, there are a number of dual enrollment courses through which students attend school at one of these employers while they are enrolled for and receiving credit from Pasco Hernando State College. And every year there's employee turnover and employees come from these school districts to the college, and less frequently, but sometimes employees go from the college to these school districts. So we think they're appropriate comparator employers. So you're going to see a series of tables like this on the slides in this section. Sort of, again, trying to avoid going through each of these proposals line by line. We're just sort of summarizing some of the main points here. First being, does the employer have discipline language in its collective bargaining agreement? Second, does that employer use the just cause standard or something functionally similar, proper cause, good cause, whatever you like to call it? Third, does that contract provide for express due process rights, as the union's proposal does today? And finally, is disciplinary action subject to the grievance procedure, which, as we kind of talked about, was a point of contention between the parties at the table. And in this case, among the comparative employers, the answers to all these questions is yes. The only technical exception is whether just cause is used at the Hillsborough County School District. And of course, if you read that proposal in detail, I think almost every arbitrator in the world would infer just cause from it. They use the term progressive discipline more often. But as you read through that proposal, it's, in all other respects, it's a pretty straightforward just cause type proposal.
What are you referring to on that one?
Yes, that's Union Exhibit 3.4 is Hillsborough County School District.
Okay, go ahead.
Thank you. Second group of comparable employees are those state colleges that are of a similar size to the school district, and here took similar size to mean essentially FTE enrollment. So in Union Exhibit 2, you can see where we have highlighted the different schools that we're including in this calculation or this group of comparators, and how their FTEs are similar to that of Pasco Hernando State College. Most of the colleges with similar FTE are already unionized, but one was not, so it was not included in the analysis, and that was Santa Fe College. Colleges that are included were, as shown on the screen now, Eastern Florida State College, Florida Southwestern State College, Pensacola State College, State College of Manatee, Sarasota, Tallahassee Community College. Those being Union Exhibits 3.9 through 3.13. So similar table as to a couple slides back. How do these collective bargaining agreements stack up against the union's proposal? The answers are almost all yes. All do have discipline language in the contract. All do use the just cause standard. The Tallahassee Community College contract does not go into any real further depth on due process rights that employees get. And all discipline is subject to grievance in all of them. The only exception is in State College of Florida, Manatee, Sarasota, where the parties in a effort to reach a compromise following a 3.5-year negotiation cycle agreed to exclude discharge specifically from the grievance procedure. I know Mr. Koji has submitted that agreement as one of the college's exhibits, so this may be one that we want to talk a little more about as we proceed here. I was actually the chief negotiator for that contract, so if we need to talk about what happened there in further detail, I'm certainly able to do that. Other similar public employers, state colleges just around the state that have collective bargaining agreements. We've highlighted, well, of those that we have not already highlighted are Broward College, Chipola College, Florida State College at Jacksonville, Indian River State College, Miami-Dade College, Palm Beach State College, and Seminole State College. So, whoops, hang on. Fat fingers, I hit a button here. Okay, let me try and share again. Okay, there we go. Everyone able to see it again? Apologize for that. Great. So again, similar table. In this case, the outlier here is really Palm Beach State College. It has discipline language, but it doesn't really flesh out any sort of standard or rights and does not subject discipline to the grievance procedure. But other than that, again, it's pretty, the union's proposal is the one that these here much more strongly conform with. I note that Mr. Koji has submitted the Florida State College of Jacksonville contract as one of his exhibits. So we may need to talk about that a little further as well, potentially in rebuttal, depending on what's being offered about it. Okay, next we also looked at the public employers, the state universities that have collective bargaining agreements. There are 12 of those. Every university in the state university system has a collective bargaining agreement, from University of West Florida in Pensacola all the way down to Florida International University in Miami.
Before I forget, you put the slides up on the screen. If you could email me a copy of this,
Absolutely.
and Mr. Koji, a copy of the slides, it would be helpful when we're done.
Not
Go
a
ahead.
problem. And these are Union Exhibit 3.21 through 3.32. And if you look at the results of that, again, across the board, all contain discipline language, all contain the just cause standard, all contain due process rights, and all allow discipline to be challenged through the grievance procedure. So within the state, we feel very compelling evidence that the prevailing practice in the industry supports the union's proposal. We also looked at the national landscape and the National Education Association, through which United Faculty of Florida is affiliated, maintains essentially a database of contracts of higher education unions which are affiliated with NEA. There are 567 collective bargaining agreements that cover or include academic employees, faculty, advisors, things like this. And of those, if you just do a simple search, 80% use just the term just cause in a disciplinary context, not including proper cause, sufficient cause, progressive discipline, good cause, or just simply cause. These are 80% that just use just the term just cause in that context, meaning, within 20 or so words of other sort of keywords for discipline, like discipline, discharge, termination, suspension, dismissal, that sort of thing. So this number would surely be higher if we, did an exhaustive, inclusive search of all different types of terms, but that's difficult to do within the system. So we just took a look at just the just cause. Okay, so next, availability of funds, because this is relatively speaking a minor factor, but certainly one to keep in mind, especially as difficult budgetary times are likely to be upon the college soon. So in our view, arbitration is quicker, less expensive than administrative hearings or trial court proceedings. Unlike in administrative hearings or trial court proceedings and arbitrations, you don't deal with depositions, you don't deal with discovery, you don't really deal with pretrial motions and things like that, sorts of things that tend to lead to a lot of attorney's fees being billed. Appeals are extremely rare, and parties can make choices to further minimize costs. They can decide that they don't need a transcript. They can decide that they're going to agree to try and use inexpensive arbitrators to the extent possible. In arbitration, those are typically the costs, or really the arbitrator's fee is main cost in arbitration. Those types of things can be minimized. So to the extent that availability of funds is likely to be an issue at all, we don't think it is, but we think that that factor would still favor the union's proposal. All right, finally, looking at the interest and welfare of the public, the sort of philosophy that I expect you're likely to hear today from Mr. Koji's presentation, it is one where the employees' interests and the public interest are necessarily opposed. Arguments along the lines of it's important for the college to retain these rights and have flexibility so that it can, deal with bad employees and this sort of thing. Basically, a worldview that views those two things as opposed. We disagree with that. We would submit that employees, the public, everyone benefits from having a transparent, fair, clear disciplinary process where a neutral third party is making the final decision. Moreover, the goal that was expressed throughout negotiations from the management team, which essentially was to keep control of disciplinary matters to the administration and the board, we don't think it will be accomplished by what it's proposing, namely to not have discipline language at all. If discipline happens and it's unjust, the union is going to challenge it one way or another. If we had waived the right to grieve discipline, we would be using that Chapter 120 or DOA process. And the employees would, if they're members of the union at least, would have the right to legal representation from the union in that process. And even without discipline articles, most arbitrators, the mainstream bulk of arbitrators, are still going to hear discipline cases, and they're still going to apply some version of the just cause standard. This is something that, in fact, the sort of authoritative texts on the matter will, directly speak to. Even when there's not specific language, arbitrators will usually imply rather, the language that the union is proposing, or some version of it, by the simple fact that there's a union, there's a grievance procedure, and there's, we have management rights in this state that provide for management the right to discipline for cause and things of this nature. Another sort of similar flavor of argument that you may hear today is that having discipline language will cause arbitrators to intrude into the domain of management, substituting their judgment for that of management, or otherwise might lead to the union to just file excessive grievances, because why not? Maybe you'll get lucky with the arbitrator, so why wouldn't you file a grievance every time? We think neither of these concerns, if expressed, would be very well founded. We just said, if there's unjust discipline, we're going to grieve it either way. If we have discipline language that provides for just cause, we'll grieve it. We'll use just cause. If we don't have it, we're going to grieve it anyway. As you heard from the faculty who testified earlier, there's been a loss of trust in the administration to fairly and even-handedly apply its policies. The college has, remember, keep this in mind, the college has 5 years to determine whether an employee is unfit to serve in a permanent status. Employees are on annual contracts for their first, usually 5 years of employment. And if they're not up to the task, they can be let go without any sort of hearing or proceeding or due process at the end of any of those years. So we're dealing with how to handle discipline for employees who have proven to a much greater extent than most other employees in most industries over a longer period of time of sustained success in their job duties, that they have earned the right to have the version of tenure we have in this state for college employees, which is known as continuing contract.
Can I just interject here for a second?
Sir.
I'm not sure how you handled a situation where somebody has less than 5 years, and I understand that the college has the right to not renew anybody with less than 5 years. But what about circumstances when somebody with less than 5 years of service are disciplined for misconduct rather than poor performance? How does that relate to your just cause proposal?
So, so are you asking how that would work if
Yes.
our proposal were adopted?
Yes.
Yes. So if an employee were disciplined during the term of their annual contract, which they generally run concordant with the academic year. So let's say in November someone does something heinous and the college determines that that person needs to be let go immediately. They cannot tolerate their continued employment until the end of the year. In that case, our proposal would provide that that employee can challenge that discipline through the grievance procedure. However, regardless of the outcome of that process, the employer would remain within its rights, essentially unilateral rights, to release that employee at the end of the year, simply because they're on an annual contract. So the employee could conceivably have their termination overturned, in which case I would fully expect the college would not renew that employee's appointment at the end of the year.
Does that include the circumstance where they just disagree with the result of the grievance procedure and are not at all challenging the competence or performance of the employee?
I'm not sure I understand the question.
Well, I mean, there are two circumstances that can happen with what I'll call non-renewal. One is the employee is engaged in alleged misconduct. An arbitrator, and you say go through the grievance procedure, can they arbitrate it? If they go through misconduct or have a grievance with respect to misconduct, can they arbitrate it under your proposal?
The arbitrator under our proposal would not have the authority to award as a remedy that the employee's contract be renewed for the following year.
I understand that. But the thing is, let's say the arbitrator concludes that the employee stole money, that's the allegation. The evidence is clear that the employee did steal money, and the arbitrator concludes that the employee should be reinstated with back pay during the term of their contract. Then we get to the renewal process. And let's say that we get to the renewal process, and the sole reason for the employer's action is to non-renew the employee because the employee, even though the employee engaged in the alleged misconduct. Would the employer have the right to do that?
I think the employer would have the right to do that. When you have a chance after today's proceedings, if you read our proposal closely, the Union Exhibit 3.1, or excuse me, Union Exhibit 1, the language in there says that the decision to not renew an employee on annual contract is not subject to grievance and arbitration, full stop. So it doesn't really matter what the reason is or whether there's a reason. Annual contract employees can be non-renewed unilaterally, and that cannot be challenged through the grievance procedure.
But can it be challenged somewhere else?
I don't believe that the administrative hearing process provides for that sort of relief. Maybe Mr. Koji can clarify. It's not, not my area of expertise, but I don't believe that the administrative hearing process can be invoked at all unless the employee already has a continuing contract.
Okay, well, I mean, the concern here is to not have the employer in a catch-22 type situation. But we'll find out later in the hearing. Okay, go ahead.
Sure. So another argument that comes up frequently is, well, arbitrators like to substitute their judgment for the proper judgment of management and give overturn terminations where there's misconduct, but the arbitrator just wants to split the baby and put the person back to work with some kind of suspension. Under the language that we've agreed to in our grievance procedure, which is Union Exhibit 4, the authority of an arbitrator to do that is pretty sharply limited. We've basically applied the arbitrary and capricious standard. So I would fully expect, and given our statements and making our proposal and statements now in this hearing, I would expect the college to argue in such an instance that the arbitrator doesn't have the authority unless it's arbitrary and capricious to overturn discipline where misconduct has been found. And I think under our contract language, the arbitrator's authority to do that would in fact be very, very, very limited. So the proposals taken in context with what we have in the grievance procedure don't really provide a regime where arbitration becomes a forum to just get, clemency from an arbitrator, unless the exercise of judgment was truly arbitrary and capricious, the penalty that management decides to implement is going to stand. We have, as a statewide organization, and this, I should have put a note here. Maybe I can draw with my pen here. But as a statewide organization, we have only pursued arbitration in a matter involving discipline of a college employee once in over 20 years. We have a fairly good record of arbitration cases in this century, at least. When you get further back into the 90s, it gets a little sketchier. But we have an exhibit that shows, exactly, I think there's 50-some different arbitrations that have been filed. Very few have been filed for colleges in the first place. I think only 3 out of the 50-plus cases we've actually had to take to arbitration. Only one of those involved discipline. And in fact, the union actually lost. So only once in the last 20 years has the union even seen fit to take a discipline case to arbitration of any kind, termination or otherwise. So any fear that having discipline language will lead to, excessive grievances being filed is, I would say, not supported by the history of our organization. There are a couple of colleges which are unionized with unions other than United Faculty of Florida. Maybe the story's different there, but in United Faculty of Florida, at least, we're not in the practice of filing frivolous grievances. So all this said, our sort of general view of the dispute before you here is you have a choice between having discipline language, having none at all. Those are the two proposals before you. That's the issue before you. Of course, you have all the liberties to formulate your own recommendation, as happens from time to time. Those are the positions of the parties. And our view of this, just in a nutshell, is, whatever marginal tactical advantage the college might get by having no discipline language at all, rather than clear sort of standard discipline language in the context of higher education in this state. Maybe there'll be a situation where there's enough fringe arbitrators on the panel that we're stuck with an arbitrator who won't hear discipline cases without a specific article about it. I think the rareness of that happening in the first place versus the ability of the parties to select sort of mainstream arbitrators on this issue is going to almost nullify that advantage completely. But even if there were an advantage, we don't think that the loss to the employees and the public of transparency in this process is worth it.
Graham, it looks like the special magistrate is not in the meeting.
Oh dear.
This happened.
Anyone know how long he dropped out?
Like 30 seconds ago.
Okay.
That happened.
It looks like quite a few, the administration side dropped out too.
Huh.
Let me see. Maybe we give it a minute and see if everybody joins back in.
Yeah.
We have technical difficulties.
Right. This is our last slide anyway, so when he comes back, I'll, as much as I liked my first speech there, I'll give it again. But either way, that was our last slide. So, all right, we'll give him a few minutes.
see a number just joined.
Yeah, I'm going to try and unmute the 727 number and see if they can. Maybe that's our magistrate. Well, I have a phone number calling me from Wisconsin. Let me see. Maybe this is him. Yes, that was Mr. Michael Setter. They're having some, I guess, internet issues. He's going to try and work them out. If he's unsuccessful, he will attempt to call in. So I'll just go ahead and pause the recording. Everyone wants to take a break. We can do that for a couple minutes here.
Okay, you may have to transfer being the host back to me.
Yes. Okay, Lauren, I'm going to pass it to you to pass it to him again. Make me a co-host, please.
You are a co-host already.
All right. Okay, I think we're set. We're recording again. Oh dear, there he goes again. Let me start
And I
recording
think
again.
you still need to transfer.
I believe you're muted, sir.
Oh, nobody wanted to listen to me anyways. Okay, so I understand that was your last slide. Do you have anything else? Yeah.
Yes, sir. Yeah, not at this time. You know, of course, potential for some sort of rebuttal or keep, back and forth might be beneficial later, but nothing. That was our case in chief.
Mr. Koji, did you have any questions for Mr. Krickelsheimer?
No, sir.
Okay. Then we'll move, Mr. Koji, we'll move to your case.
All right. Well, good afternoon. As Mr. Picklesheimer said, the only issue to be decided in this impasse proceeding is the issue of the discipline discharge article. And I would emphasize that the issue is just for this particular contract. As the special magistrate's no doubt aware, this issue doesn't decide it for all times. It remains a negotiable topic in all future negotiations, which I think is important in this particular case. Let me start by saying that the college's position is we propose to maintain the status quo as to discipline and discharge. We maintain it in the way it's been for decades now. The current status quo allows faculty members to seek an administrative hearing whenever his or her continuing contract is terminated, or if a continuing contract faculty member is put back on annual contract. It also enables annual contract faculty members to challenge and get that same administrative hearing if their employment is terminated mid-contract. Current policy does not allow for annual contract faculty members to challenge a non-renewal from year to year, but neither does the union's proposal in this case. The college's position, frankly, is to maintain the status quo because those are coextensive with the procedures already codified under Florida statutes, under State Board of Education regulations, and by college policy. It is not as if the college does not already have extensive disciplinary procedures in place. We'll go through those momentarily, or an extensive and comprehensive procedure to challenge terminations or reversion back to an annual contract. To the contrary, here, full-time faculty members, whether on annual contract or on continuing contract, have some of the most comprehensive protections of any public employee in Florida. You have that without the need for disciplinary clause in the contract. The reality is the college's position is to maintain the status quo, in large part because of the grievance and arbitration provision. What the union's proposal would do would be to allow for grievance and arbitration in any case in which disciplinary action, including contract terminations, occur. We recognize that disciplinary and just cause language and that corresponding right to arbitrate disciplinary disputes in a public sector collective bargaining agreement is not uncommon. However, in the present circumstances, including this type of contractual right, is unnecessary in light of the status quo and the history of Pasco Hernando State College. Said to that end, the full-time faculty members already enjoy the most comprehensive protections of virtually any employee in the state. By definition, you're either employed under a continuing contract or an annual contract with those types of contractual rights. Under statute and regulation, college policy, continuing contract faculty members cannot be discharged during the life of the contract, nor can annual contract faculty members be discharged during the life of the contract unless you already have certain cause. That in section 10112.83 of the Florida statute specifically provides that each full-time faculty member in a Florida college system institution, which obviously Pasco Hernando State College is one, is entitled to a contract provided by the rules of the State Board of Education here in Florida. Similarly, section 1012.855 of the Florida statutes provides that employment of all personnel in each Florida college system institution shall be upon recommendation of the president, subject to the rules of the State Board of Education relative to certification, tenure, and such other conditions of employment as the State Board of Education deems necessary and proper, and to the policies of the Florida College System Institution Board of Trustees. So clearly, Florida statute deposits this type of authority in the hands of the president as approved by the Board of Trustees of each Florida college institution, but subject to the State Board of Education rules. And what are those rules? In this case, the State Board of Education regulation has clearly adopted standards for contracts for full-time faculty members. Mr. Special Magistrate, I've included as Exhibit 10, College Exhibit 10, that is, a copy of the relevant State Board of Education rule. It's Florida Administrative Code, Section 6A-14.0411. The pertinent language there is set forth in subsection 4. And I think it's helpful to just read that. That section provides, quote, each district board of trustees may, upon recommendation of the president, terminate a full-time faculty employee under continuing contract or return the employee to an annual contract for failure to meet post-award performance criteria or for cause in accordance with college policies and procedures upon recommendation by the president and approved by the board. President or designee shall notify the full-time faculty employee in writing of the recommendation shall afford the full-time faculty employee the right to formally challenge the action in accordance with the policies and procedures of the college. And as an alternative to hearing rights provided by college policies and procedure, the employee may request an administrative hearing in accordance with Chapter 120 of the Florida statutes by filing a petition with the board within 21 days of receipt of the recommendation of the president. Importantly, and that's end quote, that's the regulation from the State Board of Education. Now, importantly, the reference there to Chapter 120 of the Florida statutes is a reference to the Florida Administrative Procedures Act. Florida Administrative Procedures Act sets forth specific criteria for the types of charges, timelines, and the hearing process that must be employed, with the end result here that anybody on a continuing contract who's discharged or is returned to annual contract, or anybody on an annual contract who's discharged midterm has these protections by Florida statute and State Board of Education rule. Now, in a moment, I'm going to ask the Assistant Vice President oversees Human Resources, Mr. Darrell Clark, to kind of walk us through what the college policies are. And I think you'll see that they're very extensive, but let me just briefly mention a couple of them now as it pertains to annual contracts, continuing contracts, discipline, and the hearing process. So first off, I'll have him walk through College Exhibit 1, which is the existing board rule 2.23. In this rule, you'll see sets forth the standard for dismissal of a full-time faculty member on continuing contract or returning that person to annual contract. Suffice to say, specific cause, which is specifically outlined in the board rule, is required before you can take that step. So with all due respect to the faculty members who spoke earlier, there is not some unwritten rule with definitions that nobody knows about. Rather, it's specifically set forth in board policy that exists today and is available to not only the faculty, but anybody who wants to see it, because all of these rules are on the internet, on the college internet site. Cause is not expansively defined as whatever the college thinks cause is to discipline somebody. Rather, it's narrowly defined. It includes such things as immorality, misconduct in office, repeated incompetency, gross insubordination, willful neglect of duty, convictions of a crime that involve moral turpitude. This is the specific definitions in that College Exhibit 1, Board Rule 2.23. Those are the only circumstances where the college can currently discharge somebody on annual contract or on continuing contract, or discharge somebody on annual contract mid-year. Moreover, also set forth in that policy are extensive due process procedures that are triggered whenever continuing contract employee is dismissed or annual contract is dismissed midterm. And as mentioned before, these track both the Florida Administrative Procedures Act as well as the uniform rules of procedure that are promulgated by the Florida Administration Commission. For your reference, if you're unfamiliar with that, it's Florida Administrative Code 28-106. But there are extensive procedures in place where, suffice to say, anybody who wants to challenge those decisions by the college are entitled to do so, and they are entitled to a full-blown hearing. College Exhibit 2 is similar. It sets forth, it's Board Rule 2.24, and that sets forth the criteria for suspension and dismissal of employees. Likewise, contains that same definition of cause to do so. It simply makes clear that these same rules apply to annual contract instructors who are dismissed midterm. College 3, 4, 5, and 6 exhibits also go, or 3 through 5 go through similar board rules that we'll get to momentarily. So that brings us to why does the college believe that including a separate disciplinary article encapsulating the just cause standard, and more importantly, exposing these decisions to arbitration, why is that? Why is it our position that that's not necessary? Well, we think it's unnecessary for a number of reasons. First and foremost, Pasco Hernando State College does not currently have a track record of taking that type of serious disciplinary action for full-time faculty members at all. Under the current president, Dr. Beard, who's been president for 5 years, you heard Mr. Picklesheimer say earlier, there haven't been any dismissals or that type of serious disciplinary action against any full-time faculty member for those 5 years. In other words, this proposal by the union is a solution in search of a problem. There isn't a problem. But in addition to not having the current track record under Dr. Beard, faculty can't even point to a track record prior to that time, because as far back as we could go, which is the prior president 10 years earlier, essentially going back to 2005, there's been no full-time faculty member discharged. This type of serious disciplinary action simply hasn't occurred. And I think that's a credit to one, of course, the faculty, but also to the administration there. And keep in mind, the issue here is this disciplinary article, is that important for this contract? So to the extent that we heard faculty members, including the union president and head of the union's bargaining committee, discuss what could happen or the potential for problems. Again, this is a solution search of a problem. All of that was purely speculative. There's no information, nor could there be, that any of that has ever happened in the last 15 years. By the same token, in addition to having already in place a fair, transparent process, to the extent that the union and faculty members articulate a concern that policies can be changed unilaterally at the discretion of the college, well, that's not accurate either. As we all know, whatever happened before the union was certified in Florida, these policies cannot be changed without negotiation with the union. So to the extent that it ever becomes a future problem, lack of transparency or arbitrary discipline, it can be addressed in the place it should be addressed, at the bargaining table down the road. And the current proposal, the tentative agreements agreed to by the parties that aren't at impasse, contemplates a 3-year contract, but with continuing reopening negotiations for all 3 years. So to the extent that any of these speculative things were to occur, they can be addressed at the bargaining table. I'd also point out that under Florida law, the college is not permitted to simply change policy. It has to do so through a procedure where it first identifies any potential changes to the Board of Trustees in advance. It can only be done at public meetings, and it takes more than one public meeting to do so. So in addition to the obligation to bargain about it, we have the state rules that pertain to promulgating rules by public bodies. I also want to address what I think the thrust of the union's position in support today of the position that discipline should be included is essentially that, according to the union, this is the most common language we see, i.e. union contracts with discipline and the right to arbitrate. While we'll certainly concede that in the context of a unionized environment is not uncommon, we think, frankly, the union's position is coming from a narrow perspective. Frankly, there are 28 state colleges in Florida. Of those, only 15 are currently unionized, meaning that there are 13 who do not have union contracts containing these disciplinary provisions. Rather, they follow the statute and regulations that I just referenced earlier. More so, of the 15 unionized state colleges, at least 3 of them don't currently have a collective bargaining agreement and haven't had one. They too then follow the state statute and regulation. Finally, I would say that, we'll go through these momentarily too, that at least 2 others, both of whom are UFF represented colleges, and that's State College of Manatee, Sarasota, and Florida College at Jacksonville, have collective bargaining agreements that do not allow for unfettered right to arbitration of disciplinary dismissals. So all told, in a nutshell, doing the math, at least 18 of the 28 state colleges do not have a codified right for discipline and grievance in a union contract subject to arbitration. Only 10 of them do. Now, I know the union referenced colleges in the area, so let's look at the state colleges in the surrounding area. Citrus County does not have a state college that is unionized at the time. Lake Sumter State College in Sumter County does have a union. It is the United Faculty of Florida. They currently do not have a union contract in place. And there are ongoing union negotiations there, so they do not have a grievance procedure with discipline subject to arbitration. I can tell you, I happen to be the chief negotiator for the college, Lake Sumter State College there, and I can tell you that Lake Sumter State College administration has not proposed to include discipline within the contract, although the United Faculty of Florida has proposed that. It remains in negotiation at this point. Polk State College does not have a collective bargaining agreement in place and therefore does not have the proposal that the union is making today governing itself. Hillsborough Community College, the one that was relied on most by the union, is the only one of the surrounding state colleges that has that. So let me speak a little bit more specifically as to the two UFF represented state colleges that while having discipline in their contract do not allow for the arbitration of disciplinary dismissals. I entered and sent to you the two exhibits, and I'm going to reference Exhibit 8 first and then Exhibit 9. College Exhibit 8 and College Exhibit 9. So College Exhibit 8 is the union contract between the United Faculty of Florida and the State College of Florida, Manatee, Sarasota. So a little bit south of our area here. And what I did was presenting College Exhibit 8, the pertinent provisions in particular. I tried to highlight what I think is the relevant language, and that is on Article 13 of College Exhibit 8, which is page 31 of the CBA, or if you're looking at the PDF file, the excerpts, it's 8th page out of 11 of the PDF file. But basically what that says, and I'll quote, it says, quote, termination of a continuing contract employee is not subject to the grievance, arbitration, hearing, or discipline termination procedures provided by this agreement. Non-renewal of a contract shall not entitle the bargaining unit member to the reasons for non-renewal. Non-renewal is not subject to grievance, arbitration, hearing, or discipline termination procedures provided by this agreement, end quote. And then further on, Article 17.3, subsections A3, this is page 42 of the union contract, or page 10 of 11 of the PDF file. It essentially says the same thing, but also confirms that, quote, bargaining unit members shall have the right only to challenge the termination action pursuant to Florida Administrative Code Rule 6A-14.0411, 7A, end quote. That's the State Board of Education rule that I quoted earlier that provides for the administrative hearing mechanism. So I think that's significant for a couple of reasons. One, it's not uncommon for even the United Faculty of Florida to agree to carve out disciplinary action, the serious disciplinary action of termination from the arbitration process. The other reason I think it's successful is this contract was just ratified by the faculty, albeit the faculty at the RC Manatee, within the past 60 days. Similarly, Florida State College at Jacksonville is College Exhibit 9. The pertinent provisions, I think, there also, which I highlighted in the exhibit, is on page 9 of the CBA or page 2 of 6 of the PDF file. And that basically provides that the discharge of a faculty member on continuing contract can be contested in an administrative hearing pursuant to that same State Board of Education rule or college policies. It does provide for an independent hearing before some other independent hearing officer, but only if the parties mutually agree to it. So here again, there's not an automatic right to arbitrate those issues. And that really is the issue from Pasco Hernando State College. We think the challenge, the right to challenge to arbitration is not warranted in this case. That the existing administrative procedure is warranted. The actual language of just cause versus the board rule that you see is not that much different. If anything, the college definition of cause or dismissal is more narrow than the typical concept of just cause. Why does the college take this position? Well, again, not only do we not have the track record, but state law, those Florida statute provisions and the State Board of Education vest these final policy-making disciplinary actions in the governing body. Most notably, the president recommends it, and then the district board of trustees is the one that makes the final decision. And the board is the one that's accountable to the college, the community, and to the state, frankly, for its decisions. It's not the case with an arbitrator. So retaining the status quo as exists now is fully consistent with the Florida legal framework. Secondarily, the president and the board of trustees are uniquely suited to make the judgments concerning the college's goals and missions and to determine whether faculty members who engaged in any conduct warranting discipline, whether they should be retained or not. To the extent that an independent fact finder is needed to determine if disciplinary action is even warranted, well, guess what? That's covered as well. Current policy provides that the board can get as Mr. Picklesheimer noted, you can get, if you're a faculty member, a hearing, an evidentiary, full-blown hearing, witnesses, documents, cross-examination, the whole 9 yards. You can get that through the board and the Florida Division of Administrative Hearings, or DOA. And while the final decision is made by the Board of Trustees, DOA, in other words, makes a recommended decision. Importantly, Florida law, case law provides that the board does not have unfettered discretion to set aside factual findings. The board can make judgment calls, but they can only set aside factual findings if there's a complete absence of substantial competent evidence to support a particular finding. So that is a process, again, already in place, and the current practice has worked. And any suggestion to the contrary is nothing more than speculation at this point in time. So in our view, those judgment calls should not be taken out of the hands of the District Board of Trustees. To the extent there's a need for fact finding, there is a mechanism within the policy to go out to that independent body, i.e. DOA, for that. What I think might be helpful at this point, Mr. Special Master, is to have my Human Resources Assistant Vice President over Human Resources maybe walk us through some of these board rules briefly, but a little more detailed than I have, if I could. I believe Rel Clark is on the proceeding with us.
Yes, sir, I am here. Thank you very much. So I think you
Can you turn on your video if you would?
can have a messy room here, but
That's all right.
am I visible to everyone?
Yes.
All right, thank you. So Attorney Koji has,
Let me do it this way, Darrell. Let me just walk through a couple of question and answer, probably the easiest way to walk us through so we can do it relatively quickly.
Sure.
First of all, let Mr. Michael Stetter know who you are, what's your position, how long you've been employed at the college.
So I appreciate that. My name is Darrell Clark, and I am the Assistant Vice President of Human Resources at Pasco Hernando State College. I've been with the college for roughly 2 years.
Okay. Who do you report to?
I report to Dr. Beard, the president of the college.
And the president, who does he report to?
He reports to the Board of Trustees.
All right. And under the state college system, who establishes the policies of the college?
The policies of the college are recommended by the president, but approved by the Board of Trustees.
All right. You're familiar with the college policies, I presume?
Yes, sir.
Let me jump to college exhibit number 5. I sent you these earlier. Do you have those available in front of you?
I do.
All right. College exhibit 5 is board rule 2.55. Is that right?
That is correct.
All right. If you wouldn't mind, walk the special magistrate through the what this policy is providing.
Absolutely. So this is just the employment contracts for all full-time faculty members. This outlined the very first section of it talks or references continuing contracts. And with continuing contracts, as was outlined by UFF representative, essentially most of our faculty members, upon completion of 5 years, satisfactory 5 years of service with PHSC, but also not to exceed 7 years, they would be eligible for continuing contract. And obviously, once the recommendation is presented to the president and approved by the board of trustees, that faculty member is, upon successful performance duties and demonstrating the professional competencies, they are approved and granted continuing contract. And the section below that, where it outlines on board rule 255, it outlines the criteria for placement of continuing contracts, where it goes through, there are quantifiable measures relating to performance. There are professional development measures as to additional coursework, licenses, certifications, etc. That factors into that equation as well. In addition to that, the current and scope of subject matter knowledge related to coursework, attendance, presentation of professional conferences, etc., factors in. Relevant student feedback for faculty members, employers of students, through the students, and administrative evaluations and peer reviews all import, are part of that equation as well. And last but not least, are satisfactory completion of 2 grad courses at either the Community College of America and Seminar in College Teaching, or an equivalent grad course approved by the Senior Vice President of Academic Affairs and Chief Academic Affairs Officer for the college.
Let me ask you this: are you able to tell us when the last time this rule 2.55 was amended?
The last time the rule was amended was in the last time it was amended was 2013. There were some non-substantive changes, which typically go towards, like, if there are title changes or report tos and things of that nature, but the actual rule was adopted or last change in 2013.
Let me ask you why don't we flip over to College Exhibit 1, which is the one primarily issued today, and ask the same question. Can you tell us what this one is and walk us through it?
Absolutely. So College Board Rule 2.223 is dismissal and return to annual contract and continuing contract personnel. And on this one here, it just outlines, number one, if the college was to take any actions towards a faculty member on continuing contract, it falls in line with the State Board of Education Rule 6A-14-0411 in subsections 4 and 5, and it outlines the items that Attorney Koji had already highlighted as it relates to whether it be changes to college, forced changes from the college, from Department of Education, immorality, misconduct in the office, incompetency, and gross incompetence, etc. All of these items are highlighted in, again, in the State Board of Education rule. And if for any particular reason there were a violation to any of those rules, then it outlines, per those rules, next steps that should be taken by the college to remedy the action.
Right. Those hearing rights and whatnot are set forth in the second part of this particular rule 2.23, correct?
That is correct. From sections 2 through 7, or sections 2 through 8, my correction.
let me ask you the same question, looking at college exhibit number 2. Can you tell us what this rule is and what it provides?
Absolutely. So College 2.24, College Board Rule 2.24 regarding relating to the criteria for suspension and dismissal of employees. Again, it outlines the same rules per the State Board of Education, State Board rules that as it relates to changes within a college, immorality, misconduct, gross incompetence, etc., or gross insubordination, etc. And it outlines all of those items. Any attempt to say, or not attempt, but essentially outline items to say that if there are issues, then the college would be able to take next steps as it relates to recommendation for suspension and or dismissal of an employee if any of those items are, if there are any violations to those items. In addition to that, it moves on to explain the annual contracts for employees as well, and how the college may take action to either suspend or dismiss an individual, whether it be during the contract year, and they have the provisions outlined by the Florida Administrative Code, as well as dismissal for that as well. And it also outlines that that if there are any issues, if there is a challenge, then a request for a hearing before the board shall be filed in accordance to the Board of Trustees Rule 1.11, conducting official college business by the board and citizens' involvement, and must be filed within 20 days of the notification from the president of intent to dismiss or suspend. The filing of this petition under this section shall not operate to delay the implementation of the president's recommendation.
Let me ask you to flip over to college exhibit number 6, Darrell. And if you would, briefly walk us through what this board policy provides.
Absolutely. So the board policy 2.59 in exhibit 6 is the disciplinary action rule that the college proposed sticking to or keeping in staying in line with what is existing practice. And it outlines the violations of rules. The Board of Trustees can authorize the following types of disciplinary actions against employees for violation of rules or laws or rules of the State Board of Education or rules of the District Board of Trustees. And it outlines a variety of different items that can be taken, whether it be verbal or written reprimands and warnings, probations, suspensions, demotions, rehabilitative service, and obviously termination. And it states that only the president or the Board of Trustees, on the recommendation of the president, may impose disciplinary actions except for verbal and written warnings or reprimands. And the president is authorized to take final disciplinary action against non-contract personnel to include termination. So it outlines the whole termination of the whole disciplinary actions that are afforded to all employees. But obviously, we are referencing the faculty members and how that will be applied, and how it is also it falls in line with the State Board of Education rules, as well as the Board of Trustees.
When was the last time this board rule was substantively amended?
This board was substantively amended in 2009. So in January of 2009 was the last time this rule was amended.
All right, and the last one, how about college exhibit number 4? What does this board rule provide?
So exhibit number 4 in board rule 2.39, it addresses resolution of employee and applicant grievances. And it just outlines the step-by-step process for which an employee would be able to file grievances, internally speaking, whether it be, through, filing a grievance or lodging a grievance with the employee immediate or hiring supervisor within 60 days. And then it goes through that, the necessary steps for follow-up with that particular employee. If the employee believes that the disposition of the grievance in step 1 is incorrect, then they may appeal in writing with the provost of a campus or to the vice president if it's a district office position. And they have a set number of days, 15 days to be exact, for the employee's receipt of step 1 disposition. They can file within 15 days of that. If the employee believes that their disposition at step 2 is incorrect, then it may appeal in writing to the president within 15 days after the receipt of step 2. And if the individual, if the grievant, or the grievant may request assistance from the director, from our director of multicultural awareness, a special assistant to the president, who is our equity officer. If they feel like that would be an appropriate procedure relevant to that particular item. But the only exception to that rule would be grievances alleging harassment. And in that particular situation, they may be filed directly with the provost by a campus physician, as well as with the appropriate vice president. And if the allegations against the provost, or if there's allegation against those individuals, the provost or vice president, then the grievance may be filed directly with the president.
All right, thank you very much, Darrell. Let me ask you just a couple of questions. Since you've been with the college, have there been any full-time faculty members involuntarily terminated who hold continuing contracts?
We have had none.
How about any full-time faculty members on annual contract, anybody terminated in the middle of their contract?
We've had no terminations mid-contract.
And did I ask you in preparation for this hearing to research, based upon your human resources role, going back all the way to 2005, whether you've had any of those?
That is correct.
And what did you find out?
We did not have any that were separated mid-contract for calls or anything of that nature.
Mr. Michael Stetter, I've got no other questions for Mr. Clark. I do have a little bit more to add afterwards.
Okay, well, does the union have any cross?
No, sir.
Okay, I guess I have one question here. How many people has the college non-renewed contracts of people under annual contract?
How many annual contracts have been non-renewed?
Has the college ever non-renewed people under annual contract?
I would say yes, that has occurred before.
And in the last, say, 10 years, how many people have been non-renewed under annual contracts? Roughly.
I don't have that number readily available for the last 10 years of annual contracts non-renewed.
Okay. Do you have a guesstimate?
I mean, given that I don't have a guesstimate because I've only been here for 2 years.
Okay, the last 2 years then.
In my 2 years, I've only seen one. I can only recall one, should I say.
Okay. Any other questions or redirect?
No, sir.
Okay. Go ahead.
All right, I wanted to just follow up with a couple of things just to tie that all together. As you can see from these board rules, the College Exhibit 1 contains a pretty extensive definition of what it takes to be disciplined. The cause definition, I said that's fairly narrow. There is a specific procedure to challenge a termination if you're continuing contract or if you're terminated mid-term under annual contract. Those are supplemented by the state, the rules of the Florida Administration Commission. So it's not some procedure that's unknown to everybody. All of it's publicly available, frankly. I think Mr. Osh said that part of the concern of the union or the faculty member was that DOA hearings and these kinds of administrative hearings rely extensively on case law and precedent. Well, frankly, from the college perspective, that's a good thing. We want that type of transparency. The college position that the existing procedure doesn't have transparency belies the history and, frankly, policies, the state law, the Board of Education, and though administrative law judges, they do attempt to follow precedent. Arbitration awards, arbitrators don't necessarily, certainly aren't bound to follow precedent, and a lot of arbitration awards are not even public, although arbitration awards in the public sector would become public if a public records request was made. To the extent that the union also indicated that the United Faculty of Florida doesn't have a history of lodging these types of grievance in up to the point of arbitration anyway at the state college level. From my perspective, college perspective, that proves our position. There is no need to have this discipline language in the contract and a procedure that resorts to arbitration. Frankly, the existing procedure, one that is followed by every single non-union state college, and it appears 5 of the unionized state colleges, works perfectly fine. And our position is to maintain that. If at any point it breaks down, parties can negotiate. As you've seen from Mr. Clark's responses here a moment ago, the college policies that we're talking about maintaining as the status quo haven't changed. They haven't changed in 9-10 years, most of them. These standards, the state law hasn't changed for as long. The State Board of Education rule hasn't changed. There is a process. It's fair and it's transparent. I know Mr. Picklesheimer mentioned a concern about the union having to resort to attorneys if we had administrative hearings. But there is the Administration Commission rules that govern those hearings do provide that you can have a non-attorney representative. You have to make a request, but that is provided by the Florida Administrative Code, and specifically 28-106.106 provides that if you'd like to have a non-attorney representative, you can make a request. And frankly, there's a procedure set forth in that regulation, and it's meant to guard against people being taken advantage of by representatives that don't know what they're doing, and which would not be the case here. The union non-attorney representatives are well-versed in the law and could easily represent anybody in the DOA hearing. So that shouldn't be an issue. To the extent that there's some potential for discovering things of that nature with administrative hearings, again, that's something that makes the process more transparent, makes it more likely to be the parties be able to predict the types of outcomes. And there's less of that when you have arbitration. We will have arbitration in this contract that's required by Florida law. The issue is, will disciplinary action be in the contract? If it's in the contract, then it's subject to arbitration. If it's not in the contract, it's not subject to the arbitration provision. That does not mean that the college, the president, or the board of trustees can take disciplinary action willy-nilly. It would still be bound by all these existing procedures. It does not mean that we somehow can change those existing procedures or policies without negotiation with the union. We can't do that. And for those reasons, we think that Mr. Special Master, you ought to adopt the proposal of the college and leave disciplinary action, the proposal outside of the contract, and i.e. keep the status quo. I will offer one last thing, and that is the union mentioned that there were a couple of these colleges did have provisions which provided that dismissal was not subject to arbitration. I pointed out the State College of Manatee, Sarasota has that provision. And Mr. Picklesheimer mentioned that it's still allowed for just cause standard and discipline short of termination of a continuing contract or return to annual contract. It's not the college's proposal today at Impasse, but the college did make that proposal as a compromise in an effort to reach agreement, avoid impasse, but that proposal was rejected. I did include that in your exhibits, Mr. Special Master. It's College Exhibit 7. And basically what that provides is it codifies the existing board policies that Mr. Clark just went through, but it makes it clear that the sole avenue of contesting the serious disciplinary actions, those terminations, is through that administrative hearing procedure, not through arbitration. But the very last section of that proposal, the compromise proposal, I call it, College Exhibit 7, provides that any other type of disciplinary action is subject to just cause and can be arbitrated, with the exception of reprimands not being arbitrable. It could be grieved but not arbitrated. And any other suspension, probation, demotions, things of that nature, not very common in higher education, but to the extent they were ever taken, this could be grieved and arbitrated. That was a position that we proposed but was rejected by the union. Our proposal today is to maintain the status quo, leave the disciplinary article out of the contract entirely. Thank you.
Okay. Does the union have any questions at this point?
Questions? No.
Okay. Does the union want to respond to that?
Yeah, there are a few comments I would make, and I think I may, to discuss the issue of Florida State College of Jacksonville, I may want to call a rebuttal witness. Well, let me start by just making a few comments. Heard a few times that the union's proposal is a solution in search of a problem. But the issue with that sort of disposition towards this is that if we wait until there's a problem, someone, if not several someone's, careers will have already been ruined unjustly, if we're at the extent where we now acknowledge that, yes, it's a problem. That, we feel, would do a disservice not only to the employee, but to their students, to other students at the college, to potential students in the future, and by extension, the general public. Rather than wait until something's broken, we have a simple solution, which in our view would prevent it from ever being a problem. And again, the advantages that the college has laid out to these, continuance of the status quo, as they've put it, the benefits don't outweigh the risks, in our opinion. I would also want to comment on Mr. Koji's statements that this is a clear, fair, and transparent process. If you look at the exhibits that have been entered, we have 6 different board rules, 1 state board rule, a very lengthy chapter of the Florida statutes, other chapters of the Florida Administrative Code governing how that statute is implemented. Maybe clear and transparent to attorneys, maybe clear and transparent to people who deal with these rules and statutes and processes day in and day out. One of the reasons that the faculty here unionized, as you heard earlier, is because the faculty they don't want to have to wonder what's going to happen or navigate all these different documents to figure out what the process is. You can have just cause language, it's just one sentence. Discipline shall be for just cause. We've proposed something a little more explicit and robust than that. That sort of explains what that is, which we think is a benefit to the employees as well as to the supervisors whose job it is to manage and, if necessary, discipline them. And we think that's a much better regime than this, overlapping dozens of pages of different documents that an employee would have to sort through to understand what they would expect to happen. One of those board rules contains a number of different things that constitute grounds for termination of employment. This was actually something that was also included in the board's proposal that it had made at the bargaining table. It includes things like, immorality, drunkenness, crime involving moral turpitude, which is defined as a crime evidenced by depravity and, among other things, depravity and private duties which a person owes to his fellow man. Not to say that such conduct is good or acceptable or becoming of a public servant, but it's not difficult to imagine all kinds of things that this could capture that really don't have anything to do with a faculty member's ability to teach effectively and discharge their obligations to the college and to the public and carry out the college's mission of educating students. We'll probably brief a little bit on some more of this, but first I'd like to call a witness to speak to some of what Mr. Koji was discussing with Florida State College of Jacksonville, if that's all right.
Okay.
And the witness I'd like to call is Dr. Emily McCann.
Okay. Yeah.
All right, you're muted. I assume everyone's still sworn.
Yes.
All right, thank you. All right, Dr. McCann, thanks for being here and testifying today. Could you describe who you are for Mr. Michael Stetter?
Sure. I am the labor relations staff who works with the United Faculty of Florida chapters north of Orlando and Gainesville. So, for example, Florida State College of Jacksonville is one of the chapters I'm lucky enough to work with. And so I support their work in bargaining, arbitration, and impasse.
Okay. So I think you heard Mr. Koji earlier referring to Union Exhibit 9, which was an excerpt from the collective bargaining agreement of Florida State College of Jacksonville. I think I sent that to you. Do you have that document?
I do. I have it in front of me, yes.
Okay. You could direct your attention to the highlighted portion on the second page.
Yes.
The very last
What exhibit number is that?
Sorry, College Exhibit 9.
Okay.
So Mr. Koji read this and commented on this proposal to the effect that the substance of this proposal is that the union cannot challenge dismissal through the grievance and arbitration mechanisms of the collective bargaining agreement. What is your interpretation of this language?
I don't, with respect, I don't share Mr. Koji's interpretation of the language. I would direct us to the attention to the portion of the language in, I guess, number 3. The parties can mutually agree to an independent hearing procedure or other alternative dispute resolution processes. Now, I can certainly understand why someone who is outside of the State College of Jacksonville might read that as a bar on arbitration. And in fact, the parties' first contract had a wholesale waiver on many alternate dispute resolution procedures. But in recent years, the parties have included grievance and arbitration language in their contract, which if you scroll through the rest of this exhibit is included. When the parties included that language on arbitration, there was an understanding at the table that 3 would be understood as referring to arbitration. Part of the reason, I imagine as a staff person, they are a very self-sufficient chapter and they engage in interest-based bargaining. So the parties have this understanding that 3 refers to arbitration and grievance, and they have practiced it as such, is my understanding.
So when a situation, if a situation, I don't know if it has, if a situation were to come up where a faculty member were dismissed, and the union said, we'd like to file a grievance about this, even if the college said, well, we'd rather you not do that, can the union still file that grievance? And if so, why?
Sure. Well, it's not expressly forbidden from 3. You also have the grievance procedure in Article 10. And you have the part, even if the college, says, gee, gosh, we really wish you wouldn't do that, the party's understanding of the terms of the contract gives meaning to the words. They have, my understanding, is notes and discussions that flesh out the meaning of 3 such that the college couldn't just unilaterally say, no thanks.
So when the parties were at the bargaining table, from what it sounds like you're telling me is that when the parties were at the bargaining table, the understanding was that arbitration is sort of pre-approved under 3, or it has to be approved each time it comes up.
My understanding is that it is pre-approved. That the parties have understood 3 to be arbitration to have been mutually agreed to through 3, whenever those are.
At the bargaining table.
I believe so, yes.
Okay. Is there anything, to your knowledge, in the collective bargaining agreement that forbids the union from challenging dismissal through the grievance procedure?
I would, in all honesty, I would want more time to review the contract, but right now, to the best of my knowledge, no.
Okay. Well, we may have more time to follow up on that if we need to, but I think that'll suffice for now. Thank you. No further questions.
Thank you.
Any cross?
Yes, I have a couple of questions. Dr. McCann, are you the one that wrote the language that we're talking about here in Article, last sentence, last clause of Article 9?
No, sir. I believe that language was produced through the interest-based process.
Right.
So between the 2 parties, but it was not me.
When the parties were at the table and negotiated this specific language, you weren't present, isn't that correct?
That is correct.
Is your understanding that this clause 3, the last section of page number 9, that the union can pursue an independent hearing procedure to contest dismissal of a faculty member under continuing contract, even if the college doesn't agree?
Could you repeat the question? I'm sorry.
Yeah, this clause, this subsection 3 of the last bullet point, it's your contention that the union can arbitrate dismissal of a continuing contract faculty member even if the college doesn't agree to it.
That is my testimony, yes. That's my
And you think that even though that clause 3 has the words mutually agree in it?
My understanding from the leaders at that chapter is that that has been agreed to at the table ahead of time between the 2 parties. And as their staff person, maybe they should update their language, but I believe what they've reported to be true.
The introductory phrase to that sentence is that the faculty member has to present this within 21 days of receipt of the president's notice, right?
Right.
So you'd have to make the selection, one of these 3, within 21 days after receiving notice of a recommendation for termination. Is that your understanding?
Yes.
If the parties had taken subsection 3, that last phrase, out of this whole paragraph, would it mean anything different? You
Would it
understand?
mean anything different? Yes, I think it would be very different if 3 weren't here. I mean, 3 is what enables them to consider an alternative process like arbitration.
Right, but even if 3 is not in there, you can arbitrate it pursuant to the arbitration article. Isn't that your interpretation?
If that's what you took to be my meaning, I'm sorry I spoke imprecisely. 3 is very much there in the language. And 3 is what enables the parties, by mutual consent and understanding at the bargaining table, to pursue arbitration for the dismissal of a faculty member under continuing contract or returning a continuing contract faculty member to annual contract.
Right, but the consent that you speak of was given at the time the language was put in there. Am I misunderstanding that part?
No, I'm explaining, I am not quite sure of the chronology. I'm explaining why they might not have what I'm saying is this highlighted in yellow thing predates some of the provisions of the arbitration, I believe. And that is why this may not necessarily, how to put it gently, why this language might seem to not have much to do with the subsequent arbitration clause is because this highlighted portion predates it. And the parties basically reached an understanding about 3 once they began adding in the other portions in 10. Or I think that's 10. Let me check the article. 10. Yeah, it's 10.
All right, that's all the questions I have.
Okay, any further rebuttal witnesses for the union?
No, sir.
Okay, well, let me ask where we're at right now in terms of, is there anything else for the employer, for the college?
Yeah, just briefly, Your Honor, Darrell Clark did send me a message that he had a correction on the number of annual contract, and if you want, I can relay it to you. If you want,
Okay.
we can get you a more precise answer in the interest there of accuracy. He's able to look that up,
Okay,
at least during his tenure.
go ahead.
Darrell, you recall the question about how many annual contract instructors that were not renewed during your tenure? I think you indicate you thought there may have been 1. Have you had a chance to look that up?
That's correct. I went back and reviewed some of the reports that we put together, and I actually have 3 on the list. I couldn't recall the other 2 because they occurred relatively early on in my tenure here at the college. One of which was a restructure where a program was essentially we ended a program at the college, so that was 1. The other 2, however, were for calls.
All right, thank you. That's all.
Provide that correction.
Thank you.
Okay, so is there anything else for the hearing part of this? And then we'll talk a little bit about what we're going to do in terms of argument, either post-hearing briefs or whatever. But is there anything else for the testimony or hearing part?
Not from the employer.
No, not from the union. I don't think there's anything that
Okay.
to say right now that wouldn't be better just, briefed on a little bit.
So the question at this point is, parties want to file briefs. I know the union's going to forward its slides, so the employer may want to file a brief, the union may not. What's your poison on this one?
I'm happy to do either or. Typically, we file a brief. I wouldn't mind doing this.
Okay. So, what's the union's position?
Yeah, let's go ahead and brief. I think that'll be the
Okay.
tidiest thing to do.
So, how long do we need for briefs?
One to 2 weeks, no more than 2 weeks. We do want to make sure that, we have sufficient time to get recommendations and consider them. And in the event we have to have a board hearing for.
Okay. So, 2 weeks then?
Works for me.
Works for me. That puts it October 13th, if I'm counting right.
Okay. And how do you want to do that? You want to exchange through me or just exchange with each other?
I think the easiest thing to do might be to just send to you and then you exchange once you've received both.
Okay, exchange. So what I'd like from both of you is sending it to me by email but also a hard copy, just in case something happens in the email process. So I'd like a hard copy. And that's to the 2680 Blue Aster Boulevard in Sun Prairie address. Are there going to be replies?
Reply briefs, I don't think so, yeah.
I don't think it's necessary. It might put the timeline out of reach of
Okay.
the meeting.
Okay, so then I'll expect briefs by October 13th. Is there anything else for this hearing?
No, sir.
No, sir.
Okay, then this hearing is closed. Thank you.
Thank you.